No cameras will be allowed inside the courtroom, and once the hearing is over, Trump is expected to fly back to Bedminster, New Jersey, where he is expected to give public remarks about the case. Let's bring in former U.S. Attorney Barbara McQuade and former litigator and MSNBC legal analyst Lisa Rubin, who is outside the courthouse in Miami.
Good morning, guys. Lisa, let's start with you on that question of the attorney. We heard some reporting from Jackie Alemany and others this morning that it won't be a problem, that there is a South Florida-based attorney who will appear with Donald Trump and that this arraignment, this hearing will go on as scheduled. Is that what you're hearing there as well?
It is. And also, Willie, to your point and the point Mika made earlier, it's not absolutely necessary that you do have a South Florida-based attorney here. It's a requirement under the local rules that you have someone licensed to practice, but that requirement can be waived for good cause shown. So either way, there was a strong likelihood, at least as of this morning, that the arraignment would take place as initially scheduled. And I and others from NBC and the MSNBC family will be inside the courthouse to bring you all the details later.
Okay, so we'll look forward to that, Lisa. Walk us through what to expect today. We know that Donald Trump has arrived in South Florida. He flew down there yesterday from New Jersey. He's going to fly back to New Jersey and make some kind of an address tonight. What should we expect to see around 3 o'clock Miami time?
Well, the most important thing that will happen in arraignment, as you already covered, is the entry of a plea. And we fully expect Donald Trump to enter a plea of not guilty. But one of the other important things that happens in an arraignment is the setting of conditions of release. And that can involve everything from the setting of a bond, which is the equivalent of collateral in a defense situation. It's essentially saying, I'm not necessarily giving you this money now, but if I flee from the forum and I have a bond of $1 million, you're free to take that. So it's likely that a bond will be set. The other conditions of release can be everything from taking and confiscating a person's passport. And then there can also be conditions on how the co-defendants interact with one another. I've been a defense lawyer in a case where two co-defendants to conspiracy charges were prohibited from talking with one another, even though one was the CEO, the other was his lawyer. Here, Walt Nauta is employed by the Trump Organization, and a magistrate judge is going to be loath to impose conditions that prevent Nauta from basically continuing on in his employment. On the other hand, it would be perfectly reasonable, given the severity of the charges here, in an ordinary course to prevent Donald Trump and Walt Nauta from having continuing contact together. I'm very interested in Barb's perspective on this as a former prosecutor with the Department of Justice.
Well, Barbara, let's get that and also talk about your latest article for Time entitled "The Dangerous Whataboutism in the Trump Classified Documents Case." And in it, Barbara, you write in part this: the indictment of Donald Trump on charges of retaining government documents brought with it the inevitable false equivalencies of the conduct of Trump's chief political rival. But the actions of the two men are different, as deliberately driving your car into a crowd of people and committing a fender bender. Both acts involves cars, but the similarities end there. Whataboutism may have become a common political ploy, but it is a trick straight out of the disinformation playbook. You continue. Whataboutism is a strategy used by authoritarian leaders to excuse their own misconduct, and that it's an essential piece of Kremlin tradecraft. The goal of this tactic is not to convince the public that the leader is innocent, but to portray all politicians as dishonest. Anyone claiming to value integrity is scoffed at as duplicitous or naive. And here we go with Trump and a lot of people who follow Trump and a lot of leaders in Congress playing that game straight on, even when nuclear secrets are involved.
Yeah, and, the comparisons here are just so drastically different from 12 documents that showed up in boxes of Joe Biden and what Donald Trump has done. That indictment, over 49 pages, talks not just about the kinds of documents that Donald Trump retained, as we discussed, nuclear secrets, but his incredible orchestration to deceive the Justice Department and keep them. When prosecutors look to decide whether charges should be filed, they are looking for those aggravating factors, not some accidental retention of documents, but deception, willfulness, disloyalty to the United States, and exposure to people unauthorized to receive them. Donald Trump's conduct here is completely different. And so when people are comparing him to others, what they really want to do is bring others into the conversation. What you won't hear is people really defending the conduct of Donald Trump. What they're saying instead is everybody does it, so what's the big deal?
Lisa, the former president's schedule today has been made very public, and he has even alluded to the very public aspect of the schedule, including flying back to Bedminster after the legal process is completed in Miami in order to make public remarks, which he definitely hopes will be televised live on at least a couple of cable channels. My question to you is, and it would be a question for the court, would any contingencies be allowed? Would the judge from the bench say, you know, you got to shut up about this trial? You have to stop trashing the process as you've done in the past. I don't want any of that. Would there be any possibility of that happening?
I don't think today, Mike, and here's why. The judge who's going to be hearing the arraignment today expects, and reasonably so, his involvement in the case to end today. He's going to be loath to set conditions that he might think are more appropriately the purview of the judges who are going to be involved in the case over the long haul. That's Judge Aileen Cannon and Judge Bruce Reinhart, who is the same judge who authorized the search warrant originally. But the other reason is Donald Trump has not yet run afoul of this particular court. And recognizing, as you just said, that he has thwarted justice and other courts through his actions, has really flirted with some really fine lines in both the E. Jean Carroll case and in the New York criminal case, I don't think we're at the point yet where we'll see any federal judge in the Southern District of Florida impose those conditions. Could those come at a later point in the case, particularly if Trump's rhetoric endangers the prosecutors and even court personnel who are involved in the administration of justice? Absolutely. But at this juncture, I don't think it's likely, Mike.
So, Barb, let me ask you about another case of whataboutism, as you write about it in your new piece, and that is one we've heard from almost every Republican who's not really defending Donald Trump, but saying, what about Hillary Clinton and the emails? What about the private server at her home? There was a 3-year Justice Department investigation into Hillary Clinton and to her server that ended during the Trump administration. We should point out that said it found no systemic, it wasn't a concerted effort, there was no effort to obstruct, that they were not doing what Donald Trump is alleged to have done at Mar-a-Lago. How do those two cases, because I think it's important to remind our viewers, how do those two cases, Hillary Clinton's email server and what Donald Trump is alleged to have done at Mar-a-Lago, how do they compare?
Yeah, so as you will recall, there was an Inspector General report about that, and then Jim Comey gave a famous press conference where he recommended that no charges will be filed. And the thing that was noteworthy there that I think is the key difference is criminal intent. To file criminal charges, you must prove as an element criminal intent. In Donald Trump's case, there is evidence that he acted willfully. That is, he knew what he was doing, and he even knew what he was doing was illegal. In the case of Hillary Clinton, as both the IG and Jim Comey said, there was no evidence of criminal intent. That she was unaware that the documents that she was seeing on the email were classified, and so that she was storing them in a way that was not within the guidance and the protocols of handling classified information. And so for that reason, these cases are very different. In addition, there was never a moment when she was told, you are retaining classified documents, please return them, and refused to do so. Yep. So the absence of those aggravating factors is what makes these two cases completely different.
So as we close out this block, Barbara and Lisa, I just want your thoughts on what you'll specifically be looking for today. Lisa, at the courthouse, why don't you go first?
I'm really looking, Mika, at a couple of things. One is I'm looking at those conditions of release, as I mentioned earlier. I'm also going to be looking at the former president's demeanor and who actually sits at the counsel table with him, because although we understand from Jackie Alimany and others that there will be a South Florida defense lawyer with him, I'm not sure we know the identity of that person yet. I do know Todd Blanche. He's someone I encountered in practice. His reputation is stellar. And I'll also be looking to see whether Todd Blanche appears to be a person that the former president listens to. We have seen a number of lawyers with prosecutorial experience enter the former president's orbit thinking that they will be the person who transforms him. They will be the person who disciplines him, who makes him into the client that he should be for his own benefit. And each and every one of them usually exit his orbit worse for the wear, if not for criminal exposure. My hope is that Todd Blanche, with whom I've had nothing but good encounters, doesn't become one of those. I'm still scratching my head as to why Todd Blanche gave up a lucrative partnership at a big New York law firm to take this case in the first place, if not for the fact that there are so many folks in the legal community who have a sort of savior complex when it comes to Donald Trump. I'm going to be the one who finally gets this guy to listen, and I'm going to win the case of the century. And I think both of those things are going to be proven not to be true, Mika.
Maybe Todd Blanche asked for the money up front.
Yes,
I mean, I'm
seriously.
serious.
Yeah.
He might have. Barbara.